the fact that it requires copies in triplicate. And in this instance, Trooper Bailey, who was the officer responding to the accident that Mr. Funk was involved in, procured a search warrant from Chancellor Jenkins at about it was about 12:40 a.m., very early in the morning of August the 5th, I believe. At that time, they met in the Rogersville Walgreens parking lot. Trooper Bailey had done the search warrant, printed it off on his cruiser printer that they have, had Chancellor Jenkins sign it there, and if your honors pay attention to the video of the stop, there is dialogue between Trooper Bailey and Chancellor Jenkins about the fact that the warrant needed to be copied or there should be additional copies made. And Trooper Bailey at that point during that dialogue admits, yes, I understand that there needs to be additional copies made. No additional copies were ever made. Rule 41 D provides that the magistrate shall keep, it says the magistrate shall prepare an original and 2 exact copies of each warrant. Considering where the interaction took place and where the signing of the warrant occurred, there was no way for copies to be made. If I remember correctly, in the record, Trooper Bailey, upon cross-examination, admits that yes, he could have gone in and printed off 2 more copies. Thus, in turn, potentially having 3 originals, but the copy requirement of Rule 41 is met at that point in time.
Mr. Boyd, can you tell me this, please? Why is this issue not waived on appeal? So let's assume that Rule 41 is not complied with, and let's assume that for whatever reason, the permissive suppression should have been granted. Let's just assume that. The issue wasn't raised in the motion for new trial. In fact, there was not a motion for new trial. And so because of that, why is that issue not waived on appeal completely?
Well, I'll answer it this way, Judge. A motion for a new trial, I believe, while it probably should have been filed, I did not file one. I went ahead and filed the appeal.
Sure.
And I'm going to answer your question. I'm going to get to answering your question, but you're going to steal my thunder on probably some of the rebuttal at this point in time. But I guess in my haste to get things done, to get it appealed, I just failed to file my motion for a new trial.
We're not looking to cast any blame or anything
I understand that.
Not at all, but just the legal effect of it, because we have held that if you don't include the denial of a motion to suppress and a motion for new trial, plenary review is waived on appeal. We've held that even in a case where if you grant the motion for new trial, all the evidence would be excluded and the case would have to be dismissed. Mm-hmm. We've held it even in that context. Do you agree that the issue is waived for plenary review now? I mean, is there any argument at all that because there was no motion for new trial that we still somehow can grant plenary review?
Well, I can say this, Judge. Should I filed one? Yes. Does that constitute a waiver? I'm going to say, give a law school answer and just say maybe.
Well, how about this, Mr. Boyd? How about this? Is there any authority at all that you could point me to, that would suggest that plenary review is still possible in this kind of circumstance?
Not as I stand here today, no, sir.
Okay. Why did you file a reply brief?
That's a good question, and I should have, again.
So the state raised the waiver issue in its response, but you still haven't even asked, even in argument so far today, that we conduct plenary review. Correct. So how do we reach the merits?
Well, to get to, I guess, what I would raise on as a rebuttal, we all have rules to follow. We all have things that we should do. Going by the line of questioning I'm receiving right now, it would appear that maybe my appeal would be denied based upon certain requirements not met by filing a motion for a new trial or filing a reply brief. So the consequences for that would be the appeal being denied. What are the consequences for Trooper Bailey's not following the rules that contain mandatory language? Okay.
Well, it doesn't anymore, though, right? So Rule 41, in terms of the suppression analysis, was amended from a shall suppress to a may suppress.
Correct.
And it may be that Michael Rath the latest case in Lowe from the Supreme Court, it may be that those cases are adopting, a general good faith exception to the exclusionary rule in Rule 41 cases. And so even if you were to apply plain error review here, it seems kind of difficult to find that there's been a clear and unequivocal rule of law that's been breached when you have no requirement that the evidence be suppressed anyway for a violation of the technical requirements of Rule 41.
And I'm sorry to interrupt. Let me, I guess, and I don't like, asking questions in an argument, but as from a rhetorical standpoint, what happens from a civil standpoint if certain things are required in a civil lawsuit and contain mandatory language about such as it doesn't matter. We're not talking about 41, Rule 41 here, right? Mandatory language of shall have 3 copies, right? There's only 1 copy, the original, okay? So what is the remedy for that? If he doesn't follow, so what is the remedy if I don't follow something and from a civil standpoint, my lawsuit gets dismissed, correct? So what's the remedy for not following that rule?
So I don't know. So let's talk about that a little further. So the rules themselves provide a remedy for that very circumstance. You're able to file a motion to suppress evidence. You can ask the court to have it heard, and the trial court can issue a ruling on that. And that's a remedy in the trial court. If you want to pursue the remedy further, though, in the appellate court, additional things need to be done in order to take advantage of the remedies that are offered. Not you, but if the lawyer wants to take it further, additional things must be done for the lawyer to take advantage of those remedies. I think what concerns me just a little bit is that even if there is merit to the argument that's being advanced, that we never get there because we can't get there. And that's why I was asking if there's a way that we could get there, because it looks like we might be precluded from doing so.
And at this point in time, Your Honor, I don't believe I can adequately respond to that point.
Fair. That's fair. How about this one on the interlocutory appeal denial? What remedy could I possibly, not me, I keep saying me, I mean the court, what remedy could the court possibly grant on for an improper denial of an interlocutory appeal when you're standing here on direct appeal now? I mean, we can't vacate the conviction because of that, right?
I would agree with that, but I would say that would gets me to the point why I should be able to raise this now on appeal, is that if a motion for an interlocutory appeal which was potentially forced upon me at the motion for suppressant because the trial court anticipated a motion for interlocutory appeal and just basically said, I know you're going to do this, so let's address it here, and went through the rule and basically denied a motion for an oral motion for interlocutory appeal, which, again, Rule 9 has mandatory language and it must be done in writing. Should I have followed it up with a motion for interlocutory appeal in writing and then had another hearing where it gets denied again? I guess I could, but... Let's even
say that all of that happened. Sure, it says it should be writing. I'm not particularly concerned about that here.
Right.
Here, though, if we both agree that your claim on the interlocutory appeal has merit, what do we do about it? Because I think we can only take it back in time to grant you your interlocutory appeal, right? Except that we have an intervening jury verdict and we have an intervening direct appeal, and that we're on here today.
And I think that's how I get here today.
You're on direct appeal today, and so I think this court recognized essentially in State versus Lalone that there's no authority that we could vacate the jury's verdict simply because an interlocutory appeal on a motion to suppress was improperly denied. And so if we can't vacate the jury's verdict, is there any remedy at all here?
Well, again, I think there is. I think that the court can develop a remedy for that, and the court can develop a remedy for that by looking at it and say, interlocutory appeal, the application for interlocutory appeal was erroneous. Therefore, it was denied, and I was not afforded that right to even look at it.
Right. But now you've been afforded the right under Rule 3 to have a direct appeal.
Correct.
And that's why we're here today.
That's correct.
So is it moot?
I don't believe so. I don't think the issue of the motion to suppress is moot. I think the issue of the interlocutory appeal at this point in time would be moot.
That's what I was thinking.
Yes,
That's a
sir.
motion for interlocutory appeal. Okay.
Yes, sir.
All right.
Yes,
Sure.
sir.
Okay, thank
So
you.
I think that's how, I guess in a backdoor kind of way, I think that's how we get here to address this issue. Okay? So what is the remedy for failing to follow the rules? It would be suppression of the blood alcohol results, which is this issue, was addressed in Coffey. Now, in Coffey, it was under the old rule that had the shall be dismissed or shall be suppressed, but the logic under that is still the same. In this instant case, under Mr. Funk's case, there was only one copy of the warrant, which was the original warrant. The state stipulated either, I believe, at the motion for suppression hearing, that Chancellor Jenkins never received a copy. It was never, of course, one of the issues too was the fact that there was never a return made to Chancellor Jenkins on that. But the court has held that is a ministerial issue and doesn't affect the validity of the warrant. So, but you look at the fact that there was only one copy of the warrant. What happens to that warrant if it gets lost, if it just gets lost or disposed of inappropriately, whatever? We have blood results then that have been taken that affect a defendant and his rights against prosecution, and the right to confront, cross-examine any witnesses or evidence at this point in time. So that severely hinders his ability to do so if that happened. And we have to look at it sometimes looking forward thinking and looking into the future. So what the remedy would be to suppress it. And I think that that's how we get here today, is that it should be suppressed because of the fact that there was only one copy. Now, it did get returned to the clerk's office, and that was an issue, but I think that the remedy would be that you go back and suppress it, and then if there's a new trial or whatever, we go back and remand it for a new trial as a result of that. Okay? I think that, again, Coffey, while under the old language of the Rule 41 that said that had mandatory shall be suppressed, I still think the logic in Coffey is applicable to the instant case. In looking at the state's argument about the good faith exception, however, on cross-examination, Trooper Bailey again, knew that his search warrants were to be in triplicate and acknowledged to Judge Chancellor Jenkins that they were to be in triplicate, and also acknowledged that there were to be additional copies or had the ability to print additional copies. As a result, we rely on the fact that would be not fall into the good faith requirements due to the fact that would be constitute reckless, deliberate, and deliberate conduct on the part of Trooper Bailey to make errors in failing to do so, and he knew the rule. This is a Tennessee Highway Patrol. That is from a law, that's the cream of the crop in a lot of ways.
I mean, as you said, the chancellor let him know, right?
Correct. And so that is something that, so what's the remedy? The remedy would be to suppress the blood results as a result of the failure to follow the rules. That's why we have rules in place. And so as a result of that, I have about 2 minutes left. As a result of that, though, I would ask the court to consider this. I understand some procedural errors and deficiencies, but I would ask the court to consider this, order or consider suppressing the blood results and return this for a new trial. Thank you.
All right, Mr. Wardle. Mr. Wardle.
Good afternoon, Your Honors. May it please the court. Garrett Ward on behalf of the state. Your Honors, I'll sort of start the state's argument this afternoon by addressing waiver, because I think that's really where any discussion of this case and this issue involving suppression has to start. Judge Greenholz, you asked in a couple of different ways why is this issue not waived? How can this court get to this issue? Is there any avenue to obtain plenary review? And the answer to that is simple. This issue is waived. This court cannot get to it on plenary review. There's really no uncertain terms here in Tennessee law. Sometimes, the correct answer on a law school exam, sometimes it's maybe, but sometimes it's just waiver. And that's the correct answer here. Tennessee law is very clear that when an issue is not included in a motion for new trial or a motion for new trial isn't filed, the issues for which the remedy is a new trial, that those issues are waived. It's what we have here. We have suppression, the remedy if applying plenary review, if this court says, if this court were to apply plenary review and say, that probably should have been suppressed, the remedy would be a new trial. So the failure to include that issue in a promptly, timely filed motion for new trial is fatal to any claim of any possible plenary review. So that leaves us only with plain error. And before I address the plain error requirements, I'd suggest that this court not engage in plain error review at all.
I mean, you say it leaves us with plain error, but the opening brief didn't request plain error. There's not a reply brief, and no request has been made today.
I think that'd be the most appropriate avenue, Your Honor. The state, in no uncertain terms, indicated in its principal brief that we felt the issue was waived and that we felt the only possible way to get to it was plain error. And as Your Honor noted, neither in the opening brief nor in any reply brief, and even today during oral argument, the defendant has never attempted to explain to this court how the 5 various requirements for plain error could be met in this case. So I would suggest this court not engage in plain error review of this issue at all because it hasn't been requested. Out of an abundance of caution, should this court choose to review the issue, this court should affirm the trial court's ruling because the plain error requirements can't be met here. As Your Honors well know, since the Coffey case, which is the principal case the defendant relies on, from about 20 years ago, since that case, Rule 41 has been amended to remove mandatory suppression as the remedy for noncompliance with Rule 41. There is a remedy for noncompliance with Rule 41, and it's to file a motion to suppress and to have the trial court consider it. It's precisely what happened here. There is no breach of a clear and unequivocal rule of law in this case because all the trial court does is it takes the discretion given it by the amended version of Rule 41 and rules on the suppression motion.
But both, I mean, if we're going to go here, I mean, both Lowe and Michael Rath identify factors that the trial court could consider when deciding whether to suppress evidence for a technical violation of Rule 41. One of those factors, because the whole rationale behind the good faith exception to the exclusionary rule is that the exclusionary rule is meant to deter police misconduct, right? And so where you have reckless, intentional police misconduct, those are the types of cases in which suppression would be warranted. I think both Lowe and Michael Rath acknowledge that. In this case, you have the chancellor, the issuing magistrate, telling the trooper, these need to be in triplicate. The officer testifies, yes, I knew they needed to be in triplicate. The officer testifies, yes, I had the ability to do it on scene. I think all of us who have been trial judges have been out, late at night meeting at a gas station somewhere trying to sign warrants and making sure we have them in triplicate because everyone knows that. And it looks like in this case, that evidence points to an intentional disregard of the requirements of Rule 41 when he's being told that by the issuing magistrate. He knows that Andy has the ability. So it may actually be at least arguable that there is a breach of a clear and unequivocal rule of law. I mean, requirements of Rule 41 are pretty clear, and in this case, there is a reason that maybe suppression should have been granted if we're going there.
So again, I think this court would be well entitled to not go there. But since I have opened my mouth, I'll address Your Honor's question. I push back slightly on the characterization of Trooper Bailey is sort of intentionally flouting the law. There is some discussion on this video from both the Chancellor and from the Trooper about, look, this needs to be done in triplicate. I'll note Trooper Bailey does ultimately make 3 copies of this warrant, just not on the scene. It seems, not to necessarily put myself inside Trooper Bailey's head, but it seems what we have here is just a misunderstanding of when there need to be these 3 copies generated. That seems to be the nature of his misunderstanding of the rule, and he does misunderstand the rule. And if the question were, was there a breach of Rule 41, if that were the clear and unequivocal rule of law itself, we'd be in a different scenario. But that's not really the question. The question is, was there a breach of clear and unequivocal rule of law when there was no suppression? And I'd suggest to this court that there wasn't. But again, given the nature that this issue has come to the court, I don't think there's any reason for this court to consider the issue, given the strength of the state's waiver argument.
Your friend on the other side, I believe, conceded that the argument that he should be granted an interlocutory appeal is now rendered moot by the direct appeal. What's your thought?
I generally agree, Your Honor. The purpose of filing Rule 9 is to get this court to look at an issue, and this court is now examining that issue.
Okay.
So it would seem to me the only remedy, if a Rule 3 appeal is even a possible appropriate avenue for seeking review of a Rule 9 denial, that the only possible remedy for that would be allowing the defendant to present the issue on direct appeal, which he's done.
I thought in Lalone, actually, we identified the remedy for improper denial of a Rule 9 application, and that's a Rule 10 application.
It seemed to be the wisest course of action to me, Your Honor.
Okay.
If a defendant thinks the trial court should have granted a Rule 9, that Rule 10 is the most appropriate avenue. But unless this court has further questions, I would ask that you affirm the judgment of the trial court.
Thank you, Mr. Wardle. All right. No. Vote? Okay. Yes, Sam. Waive it. All right, counsel.
Mr. Boyd, it's good to see you today. Thank you. General.
Thank you for being here. That concludes today's docket. We'll be back in the morning if anyone wants to come.
All right.